This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.
Hello, everybody. Thank you for joining us today. My name is Juan Carlos Brando, and I'm good. I'm really happy to be back with you all. Today, we're going to have our live attorney, Francis Fonseng, who is one of the partners of the law firm, and he's one of the main attorneys that has a lot of knowledge. He's one of our, I would say, doctrinaries in the law firm, determining how we will do some procedures in the immigration field. And he has been working for several years with the law firm of Margaret W. Wong. The attorney Margaret W. Wong is in another activities today, so she's not available now, but we have the attorney Francis Fonseng, who is really amazing. He is awesome, and he's one of the best attorneys that we have in the law firm. Attorney Francis, thank you very much for having us today. Thank you for your time. How are you doing today?
I'm good. Thanks for having me here.
Thank you so much, Attorney Francis. Well, it looks like we're a little bit more steady now in the immigration field, receiving a lot of good news, but we need to really understand what each new means for the immigration field. We have heard about the working authorizations. We have heard about driver licenses. We have heard about the Niz Chavez case, and I don't know where to start. But let's start with the work permit. Is there any change about the possibility of filing working authorization for people who are applying for asylum?
Well, there are two different updates to work permits recently. One update is that someone who has a deportation order, who's been ordered to be deported, and who is on order of supervision with ICE. That means reporting to ICE every couple of weeks or every couple of months. They used to be allowed to apply for work authorization while they are reporting. The previous administration tried to cancel that policy, but just recently, this past week, the current administration decided that that policy is back on. So people who are on order of supervision can continue to apply for work authorization. Second thing is that there used to be a 30-day rule for people who are applying for asylum. If you apply for asylum and you apply for a work permit, the Immigration Service is supposed to approve the work permit within 30 days. Now, unfortunately, the Immigration Service has removed that 30-day timeline, so now it can take however long it needs to take to approve the work permit. So it might take longer for asylum applicants to get their work permits.
Okay, so in this case, for asylum applicants, we're talking about the 150 days or the 365 days?
Well, this is for people who have applied for their work permit and are waiting for the card. It might take more than 30 days to actually get that card in the mail. So this just happened in the past week.
Oh, okay. Well, regularly, some people are waiting for 4 or 5 months to get the card back. So it seems like it's positive news. If you have any questions, please feel free to write them down in our transmission right now. We will ask these questions to the attorney, Francis Fonseng, who has a lot of experience. And if you have more questions, you can call 216-279-3984, 216-279-3984, the office of the attorney Margaret W. Wong. And about the Niz Chavez case, we've received a lot of calls of people saying, I have a deportation order back from 2010, from 2013. I never left. And I would like to know if I can apply or if this will benefit me. But what can you tell us about this decision?
Okay, so the Niz Chavez case is a recent decision by the US Supreme Court, and it is all about what's called the notice to appear. The notice to appear, or the NTA, is what the Immigration Service issues to you, the paper that puts you into the deportation process, that starts the deportation process. And so the notice to appear is supposed to have your name, your address, the reasons that you are unlawfully in the United States and subject to deportation, and also the location, the date, and time you were supposed to appear in the immigration court. Okay? The problem is that for a long time now, many years, the NTA did not have the date and time and location of that immigration court hearing. It would say to be assigned or to be determined. And then later on, when a hearing is scheduled, the court would mail a hearing notice to the person. Now, over the past few years, there have been a few decisions by federal courts about whether the NTA, without the date and time of the hearing, is that a proper NTA? And does the court have jurisdiction? Can the court actually process the deportation case for that person? Now, the Supreme Court in Niz Chavez said, if the NTA does not have the date and time, it is not proper. And even if the court sends a hearing notice later that does have the date and time, that does not fix the original paperwork. And so that means, how does this help you? So two different situations that this could help you. First, you have to look at your case. Do you have an NTA? Look at the NTA and see, is there a date and time and location at the bottom for your court hearing? Now, if it does not have the date and location of the hearing, then it's possible that number one, you can reopen your deportation case if your case has already been denied and you have an order of deportation. Number two, you could try to terminate your deportation case if you have an ongoing deportation case, because you can say that the judge does not have jurisdiction until the Immigration Service fixes that NTA. And third, most importantly, there's what's called cancellation of removal, or 10-year cancellation. That's a process where the judge can approve your green card if you've been in the United States for at least 10 years and you meet some other qualifications. But the most important part is you have to be physically present for 10 years up until the date the NTA is issued. Now, if the date NTA is not proper, then the 10 years could keep running until the NTA is fixed. So even if you don't have 10 years as of the date of the NTA, it's possible that you have the 10 years now and you might qualify for cancellation.
Okay, so let me see if I understand this. So basically the court was sending me the NTA before I could get to have 10 years in the United States just to stop the clock? So that's what they were doing?
Right. So whenever the Immigration Service wants to start a deportation against you, they issue the NTA, and that would ordinarily stop the clock for the cancellation of removal.
So that would affect me from getting my 10-year my 10-year cancellation process.
Correct.
So if it didn't have the date of the hearing, then now I can fight.
Right. If it didn't have the date of the hearing and now you have the 10 years, then it's possible you can apply now.
Wow. That's why this decision is very good. And thank you for the explanation. So if this is your case that you received the NTA, you just need to go back to your paperwork, to your documents, and check your NTA. If they sent it to you and it doesn't have the date of the hearing, and now you have over 10 years in the United States, you can start a process for 10-year cancellation. So please give us a call. We will be happy to help you check your case. And as the attorney Francis is explaining, there's a lot of issues with this, with those NTA, because they were basically using it as a trick just to stop the clock and affect people from having the right of fighting for a cancellation of removal. So if this could be your case, please give us a call today to 216-279-3984, 216-279-3984. And thank you so much, Attorney Francis, for this explanation, because it clears a lot of doubts that I had in my mind. And I'm sure a lot of people are just waiting to know what could happen with them. What happens if this person was never removed from the United States?
Well, if the person was never removed from the United States, has a deportation order, it's possible that we could reopen that deportation case based on this new Supreme Court decision. Now, what if you received the NTA? It didn't have a date and time of the hearing. Later on, the court mails the hearing notice, but you never received that hearing notice. And so you didn't know you had to go to court. And so now you have a deportation order called an in absentia order because you didn't show up to court, but you didn't even know you had to go. So now it's possible, maybe we can try to reopen that deportation case and give you a chance in front of the judge.
Okay, thank you so much, Attorney Francis. This is a very good thing because we have a lot of people that don't know that they have an order of deportation. So please give us a call, 216-279-3984. And what happens if I was actually removed from the United States, but I came back?
Well, that made things more difficult because if you were removed and then you came back, that gives you what's called a permanent bar, a 10-year bar that usually you can't just apply for the green card because the Immigration Service can always use that deportation case against you to deport you again. But it's possible that we can try to reopen that original deportation case to try to clean the slate, to start over again. But we won't know until we see the specific circumstances.
Okay, thank you so much, Attorney Francis. And we have more good news about the law firm because the attorney Margaret W. Wong will start traveling across the United States. And the team is going to start traveling to some of the offices. So just write down the date. People in Chicago, Illinois. The law firm will be present giving consultations in person on June the 8th. June the 8th in Chicago, Illinois. The team of the Margaret W. Wong and Associates law firm will be in the city of Chicago taking care of your needs. So please call right now, 216-279-3984, 216-279-3984, and make your appointment right now because they will be taking care of your immigration case in person. And also in the city of Nashville, Tennessee, the law firm will have their attorneys taking care of you on June the 14th. So please call 216-279-3984, 216-279-3984, and let them know that you will be having a consultation in the office in Nashville on the 14th. So on the 8th of June, Chicago. On the 14th of June is Nashville. And thank you so much for trusting this law firm that has over 40 years working in the immigration field and has 9 offices in the United States: Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one, 216-279-3984, 216-279-3984. We have this question, Attorney Francis. What are the chances of getting approved for fiance or spouse visa in case we apply the timeline and what kind of waiver do we exactly need and how long does it take as well. We have been doing our research, but there are a lot of waivers, and I'm not sure which one is the best to use if ever we might need one. We've been apart for more than a year, and the clock is ticking for fiance visa 2 year window. I really want to be together with my partner already, and I want to believe that we can be together again. It will also be helpful if there are lawyers out there who are experienced with this case. Thank you for your help. It looks like this person is looking for either the fiance visa or the spouse or the spouse petition. What would you recommend?
Well, it sounds like that the couple is separated right now. Maybe the U.S. citizen is in the United States and the fiance is overseas. So you mentioned waivers. So we would need more information about why you think you would need a waiver. A waiver is used to forgive an immigration problem. For example, if the foreign person was in the United States illegally for more than 1 year, then that person would need a waiver of a 10-year bar from coming back to the United States. Or if the foreign person used a false immigration document or lied to immigration, misrepresented information, then there might need a fraud or misrepresentation waiver before he or she can get a visa or green card.
It looks like this person was turned back from the airport in LA because he apparently admitted that he was working in the United States with a tourist visa.
Okay, so if he was turned back, then we would need to look at that airport documentation to see, was he expedited, removed from the United States? So was he deported? Or was he allowed to withdraw his application for admission? That means he just gets back onto the airplane and leaves. If he was expedited removal, then he would need a waiver to forgive that deportation. If he just withdrew his application for admission, he does not need a waiver for that. Now, sometimes at the airport, the Immigration Service will find fraud or misrepresentation if they see that you were lying about working or not working while here as a tourist. So we would also need to figure out, do you need a waiver for that? Okay.
Okay. Yes, go ahead.
And so after we have that information, we can either file the fiancé petition, or if you are already legally married, maybe you can go back to the foreign country and get legally married there. It does not matter where you are legally married, whether it's in the United States or overseas, that marriage is legitimate for immigration purposes. Then we can file a petition, get to the interview at the embassy, and see if we have to file any waivers at that time, because in the end, it's the consular officer that decides, do you need a waiver or not? And then we can file a waiver after that interview if needed. Okay.
Okay, perfect. Thank you so much, Attorney Francis. And don't forget to call. The phone number is 216-279-3984, 216-279-3984. The attorney Margaret W. Wong has 15 attorneys working with her that can help you in your immigration needs, and they have specialties in different areas of the law. For example, work-based visa or employment-based visas, family-based visas, and cancellation of removal, asylum. Everything you need is in the law firm and is separated in departments. So they will work in your case. People that are specialists in your area, they will help you out, and you will get the immigration relief that you actually need. So thank you so much for your questions. I have another question coming in. And this question says, I have the conditional green card. I have the conditional green card, and I have to renew it, but I don't know if I need to do the renewal or just file the removal of condition, or if I have to do them together. she's married to an U.S. citizen.
Okay, so we get this question a lot. There's two different forms that we're talking about. One form is the I-90, and that's to replace or renew your existing green card. And then there's the form I-751. That's the petition to remove the conditions on a green card. Now, if you have a 2-year green card because you received it through marriage or through investment, that means that it is a conditional card. The 10-year green card is the permanent card. To remove the conditions on a marriage-based green card, you have to file the form I-751 in the 90-day period before that 2-year card expires. You do not have to file form I-90. I-90 is only if you are renewing a 10-year green card or you lose your green card and you have to replace it, okay? So file form I-751, not form I-90 in this situation.
Okay, thank you so much, Attorney Francis, for the information. And don't forget, the phone number is 216-279-3984, 216-279-3984. And just reminding everyone that if you have a removal order and you were never removed, or it doesn't matter what the condition is, right now, check your NTA. And if it didn't have the date of the hearing, then you need to call the office right now, because that could be an issue in the process. And that's what the Niz Chavez case is about. And we might be able to help your case. So please call right now if you have a removal order, 216-279-3984, 216-279-3984. We have another question coming in, Attorney Francis, and it says, okay. My husband dropped off his passport at India for visa with documents, taxes, translate. It's been 2 weeks. They didn't send his passport to his address. So what should I do for that? Maybe he was there just for the visa interview, is what I assume, and is in India.
Okay, so if you go to your visa interview at the US Embassy, you usually drop off your passport, because if the case is approved, the embassy will stamp the visa in the passport and then inform you when and where to pick up your passport. Now, 2 weeks is a pretty long time. If the embassy decides they're not going to approve your visa, they will usually tell you to pick up your passport. If they keep the passport, that could be a good sign. Maybe there's administrative processing, or there's some checks that the embassy has to go through before they issue that visa, okay? Now, 2 weeks isn't that long. If you're curious, then maybe send an inquiry or an email to the embassy to ask for an update, what's going on with the case, okay?
Okay, thank you so much. And maybe if this helps, remember that India is going through a very, very, very hard time right now with COVID-19. We had over 800,000 people infected in just 3 days. So they are in a very critical situation right now. So maybe that means the delay about the passport. So just be patient, please. And hopefully you will have an answer in a few days. So the next question is, I came to the United States in 2008 on J1 visa. Then I went back to India. Now it's time. I came here in a B1, B2 visa. I don't want to go back right now because of some personal issues. I want to live here. Can I go for asylum or any other way? Please let me know.
Okay, so you have a couple options, okay? So when we talk about immigration, we talk about parallel tracks. There are two sides. On one side, you have the non-immigrant options, the temporary visas. On the other side, you have how to stay in the United States permanently, the immigrant options. If you want to maintain your non-immigrant status, you came here on the B1, B2, and maybe you want to just extend your stay for a little bit, okay? B1, B2, you're allowed to stay for 6 months. So you can file an extension of that B1, B2 for an additional 6 months if you want to extend your temporary stay, okay? Another option is if you decide that you want to become a student to attend school in the United States, you could file to change your status from B1, B2 to F1 student, okay? So these are some of the non-immigrant options. Now, you had talked about asylum. If you have some personal issues or experience some harm or some threats in India and you can't go back there, or you're afraid to go back, then maybe you think about applying for asylum. What's important is if you want to apply for asylum, you would have to file within 1 year of entering the United States, okay? The 1 year deadline is very important. It is much easier to get the asylum case approved if you file within that 1 year. Now, we would need more information about your story and about why you can't go back to India, so you can contact our office to set an appointment to discuss that.
Okay, thank you so much, Attorney Francis. And yes, please give us a call. The phone number is 216-279-3984, 216-279-3984. And the law firm is starting to do in-person consultations. We have been doing it over the phone or over video consultation due to this situation of COVID-19. Luckily, we are fortunate that this is coming to an end, at least in the United States of America. So we're starting to travel, we're starting to see people again. The more people get vaccinated, the more people we can see. And that's a good thing to know, that the country is little by little going back to normal. But the good news is that we are starting to see people in person again. On June the 8th, the law firm will be attending people in Chicago, Illinois, in the office of Chicago, Illinois. And in June 14th, the law firm will be attending people in the Nashville office. So please give us a call, make your consultation appointment, and 216-279-3984, 216-279-3984. Okay, so Attorney Francis, this person says, I have a question about my immigration status. I need help to file my citizenship. What can I do? This person, his name is Mohammed.
Well, first of all, if you want to apply for U.S. citizenship, you have to have had your green card for a certain period of time. If you got your green card based on marriage to a U.S. citizen, or you are now residing with a U.S. citizen, and you've lived together for at least 3 years with your green card, then you can apply for U.S. citizenship right now. If you got your green card any other way, or you're not married to a U.S. citizen, you have to wait 5 years before you can apply for U.S. citizenship. Now, in that 3-year or 5-year period, you have to show that you are a person of good moral character. That means you don't have a serious criminal offense or conviction within that period, okay? Now, whether it's serious or not, I would recommend you talk to a lawyer with that criminal conviction paperwork just to make sure you don't run into any problems before you apply for U.S. citizenship, okay? Another factor is physical presence and continuous residence. You have to be physically present in the United States. That means physically here for at least half of that period of time, whether it's 3 years or 5 years, physically here for half that time. And you have to be continuously residing in the United States. That means that none of your trips overseas were too long. No trips over 6 months in general, okay? And so otherwise, if you have a very specific issue, then get in touch with us. Hopefully we can answer your questions.
Thank you so much, Attorney Francis. And our time is up for today. So thank you so much for your time. We hope to talk to you soon. And we know that the office is getting very, very busy right now. with a lot of cases, but we are still being very successful and getting good answers and responses from the organizations of the immigration field. So thank you so much, Attorney Francis, and see you next time.
Okay. Thank you, Juan.
Thank you so much. And for everybody who is joined us today, please give us a call, 216-279-3984, 216-279-3984, the law firm of Margaret W. Wong.
This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.